Hello, everyone. My name is Eleanor Curry. I am the managing attorney here at the Curry Law Firm. Obviously, we do some estate planning here at the Curry Law Firm, and we're talking about something that is very near and dear to my heart. We're talking about caring for everyone without losing yourself. So, if you are a caregiver, I assume you're attending because you anticipate being a caregiver. You know personally how exhausting that role can be, how tiresome it can be to your own personal energy and your own personal space, but the love you give when you're stepping into the role of a caregiver. So, we're going to talk about some of the considerations you might have as a caregiver when it comes to planning for the next phases. Now, lots of these conversations are uncomfortable. No one likes to think about next stages. However, it is a natural part of life, right? And so when we talk about transitioning, a lot of time it may feel like it's something that you don't want to talk about, or if you talk about it, you're going to bring it about faster. But none of that is true. The truth is, transition is a part of life, and we will all transition at some point. And making it as smooth and easy of a process is an important part to your peace of mind if you're a caregiver. Um, Certainly, if you have someone that you love and you're caring for, that they probably would have had in their mind if they had the capacity to do so. And so, this is an extension of the act of love that you are already extending as a caregiver. Um, about me, of course, I'm the founder of the Curry Law Firm here, and we have a real passion towards helping families protect their wealth, their businesses, and their legacy, particularly through estate planning, because we can see generational change in those structures. And we work closely with caregiver parents, multi generational families, to put together legal plans that really protect them and enshrine their wishes in a way that can move forward and can move from a thought to an action. And so, in that space, we work with a lot of entrepreneurs, real estate owners. There's lots of places where you can make a real impact. And the reality is, it does not have to be a place where you say, we have multi millions that we're managing. We're trying to do, name the side of our alma mater. It doesn't have to be that elaborate. It can be a simple plan for your family and ways that you can move that plan and that legacy and that mentality forward to future generations. So at the Curry Law Firm, beautiful picture of my staff. So it's not just me, but we do support business owners and real estate investors, service providers, and families who really have a focus on generational wealth building and building something beyond the state of what they have. So if you have an imagination, you're probably a good client here for the Curry Law Firm. We like to think big and help our clients put big plans in action. So today we'll talk about the reality of women. March is Women's History Month, and so we'll be talking about women because lots of times we are caregivers. But fellas, if you're out there, if you're watching, you also can be very kind and attentive caregivers. So we're going to talk about the realities of that, some legal risks that you might face if you're in that position as a caregiver, the basics of estate planning. So you could do some high level things. You could have multi-level trust. You can have multi-generational trust set up, but you may just want to say, hey, we want a plan in place. My mom wants this. This was important to her, and I want to carry through with that. So it can be simple or it can be very complex. And then some other things, power of attorneys, healthcare planning, because it is not all. You may bypass all of the things that are more higher level estate planning. You may even bypass a will. And there's certainly options to help you and allow you to bypass that. And if you have the education, if you have the information, and if you understand what you're doing, that may be a perfectly viable option. So women, again, it's Women's History Month, and women's are the backbone of caregiving. How do we know? Statistically, 60 to 70% of women play that role in their families. Many care in the sandwich generation, what they call me, in my generation, they care for children and aging parents. And that has an impact. It has an impact on your income. It has an impact on your own income potential, your own retirement, and just the way you think about life and how you spend your time and your resources. And so when you think about that, yes, you want to protect your loved one. You want to make sure they have what they need. You want to make sure that they're provided for and that their assets aren't wasted. But it also is beneficial to you as we talk about some of the next stages of what happens as you care for them and as they transition. So let's talk about the reality. The emotional reality of caregiving is exhausting. There's no way to describe it other than that. And if you are currently in a role as a caregiver, I recommend to clients all the time, go find a support group for whatever you're doing the caring for. Because if not, you could find yourself burnt out and feel guilty, sad, frustrated, because of those feelings that are perfectly natural. So that is just an aside, but certainly you can feel emotional strain, you can feel burnout. There's a lot of financial pressure. You may not be able to work as much or as frequently. You may turn down opportunities because of your responsibilities. There may be conflict within your family on who does what, or you may be feeling like I'm the only one who's doing anything. I'm the only one who's paying anything. And there's major, serious decisions on what to do next when it comes to healthcare responsibilities and making decisions for your loved ones. So we will kind of talk about that as we go forward. So why caregivers need estate planning? One, managing things aren't easy, and lots of times you need empowerment in order to do so. If you are a caregiver, and let's say you are one of 4 children and no one puts a plan in place, then technically all 4 children, as heirs, have a right to make medical planning decisions, right? And you may be the closest, you may be the one there, boots on the ground, actually doing things, but the legal requirements state that everyone has a right to make legal decisions. Now, you guys can do it jointly, you could do it separately, but the hospital is not there to navigate, or a skilled nursing facility is not there to navigate who does what. They're only there to accept instructions, and they're there with the law on their side to say what legally they can allow and who can make decisions. And so you typically are not only managing healthcare decisions, you're also managing the finances, what can be afforded, what is in the budget, what's not in the budget, what is on your wish list for the budget. And if you have not been in that position, you'll find that that budget is expensive. It can be very expensive. And oftentimes, by the time you need assistance from any governmental agency, Medicaid, for instance, if you have not put a plan in place, it may be too late to access those benefits. Protecting dependents. You may be dependent, but as caregivers, it may not be a parent and with adult children. You may be a caregiver to your children who are growing and who do not have someone themselves or even an income themselves to manage. So if you are managing the care of someone under your protection who may be younger than you, who can easily be taken advantage of, if not protected, if not monitored, you are in the protector role. And certainly ensuring legal ability to act. Who can say and do what? That's a big question we frequently face. And if you do not delineate who has the right to do what, again, the state has defaults. The hospital will refer back to who meets the defaults of the state, and it may be the least likely candidate and the least appropriate candidate who steps up or who is available and then makes decisions that are irreversible. So the risk of just helping, if you're just kind of dibble and dabbling in helping someone in a caregiver position, certainly banks can deny access. Everyone wants to be protected. Hospitals want to be protected. They're a business, and they also have some some heart to the business, but they are a business, so they want to be protected. They don't want to be sued for accessing or giving authority to the wrong person. Certainly, banks do not. Doctors, due to HIPAA, have certain requirements on who they cannot speak to and what authority they have the right to speak to people on. And if all else fails and you have to take to the court system through a guardianship appointment or through some other type of appointment, the court may deem no one is likely, or that because of the fighting between people who do have a right, they want to appoint somebody who's completely neutral in the court's eye, but who is the third party, so who may not have the heart or have the understanding or the background to what that person may want. And in that sense, they may make a bad decision or a decision that is not aligned to the wishes of the person in question. So special needs planning, that allows families to provide financial support for those with disabilities without jeopardizing their governmental benefits. And there are a variety of benefits that protects. Primarily, people are looking at Medicaid. And if you've been in the process or you're beginning the process, you will find that Medicare still has some client responsibility. Like if you're a patient on Medicare, there is a donut hole, they call it, where you have to pay a deductible. After that donut hole, you have to pay your 20% of whatever Medicare does not cover. And then even after that, if you reach their policy limit, then you are fully responsible for what Medicare pays. So Medicaid is separate and different. They work as a different entity because they focus on a certain segment of the population that is considered to be low income. They cover things fully. So as a quick resource, if the healthcare facility costs $10,000 a month, Medicare would pay a portion of that, but up to a certain amount of days. It may be as short as 60 or 90 days, where Medicaid may pay for that indefinitely, fully, right? So you still will have your Medicare deductible and responsibility, where Medicaid may fully cover that. And if it's a $10,000 bill, obviously that could be a savings of many thousands of dollars every month. But you have to qualify. So a special needs trust or special needs planning thinks about how you can meet the qualifications of particularly Medicaid, but a variety of governmental benefits without busting out. And you bust out honestly quite easily by making too much money, by having too much money come into your possession, by owning too many assets, all those reasons where you would be disqualified for Medicaid. Or if you provided applications where you did qualify and they later found out that you had assets that exceeded their minimums or their maximums, then you would be responsible to reimburse, or the estate would be responsible to reimburse Medicaid for any expenses incurred during the period. So it particularly, a lot of clients who have incapacitated children, their children has some sort of disability that they can see going forward. They may already be on benefits. They may need benefits in the future, even if the family is supplying the cost currently. Often it can be very difficult to supply those costs indefinitely. And as caregivers, you have to wonder, if I'm not here, who could provide this level of service? Maybe I'm doing all the care, I'm doing all the picking up, but if you weren't there, who could do that? And if the answer is no one could, then they would have to go to a facility or need a private nurse who's going to cover those costs. If you did venture into the special needs trust arena, then certainly the cost could be paid for by that trust. And a special needs trust could cover a variety of things that are required. It's usually under the umbrella of care, comfort, and support. So that may be education, therapy, and rehabilitation services, access to facilities and travel. And they're important because without proper planning, again, the state always has a default. And that default is typically what's called the guardianship process. And that process takes time and costs money. So going through guardianship is not instant. And they do appoint a outside kind of overseer to that process, which is called an ad litem. So you have to pay the ad litem, you have to pay the attorney if you're going to engage an attorney, and you have to wait. And even in simple cases, that wait could cost a year, because that ad litem is going to do their research. They're going to identify the person in question and make sure from their doctors, from their own perspective, they do indeed need care and guardianship. And so that is an investment that can be, if it is the right candidate, a prime candidate for an alternative in special needs trust. So if you have a child, an adult child particularly, that's incapacitated, there's no way around guardianship, unfortunately. In order to do a trust, I take that back. There is a way around guardianship, but it requires planning. If you don't plan, then you have to get guardianship, because you have to be okay and say, I'm making medical and financial decisions for this person before authority. I heard a judge the other day say, almost a stripping of someone's rights, right? At 18, the state naturally gives you rights. It says you have reached the age of majority and you can make decisions for yourself. And the guardianship process says we take that back. This particular person can no longer make decisions for themselves. And in lieu of their decision-making skills, the guardian will do it. So adult children with developmental problems, for instance, adults suffering from Alzheimer's or dementia, individuals with severe mental illness or severe physical illness, all of them may be prime candidates for guardianship. That process in the state, of course, you're going to apply a guardianship application. As I mentioned, and that LIDM will be appointed from the court. They're going to do research. They're going to talk to doctors. They're going to talk to the person if available. They're going to talk to you as a guardian, and they're going to make sure from the court's perspective, they're putting that person in good hands. Now, it's a public process, so if someone wanted to object, they shouldn't be guardian. I should be guardian. They want to steal their money. They can present facts about you, about your life, about your financial situation. And so it is completely contestable because the court is going to listen to anyone who may have relevant information that helps them make a determination to award guardianship. Not only that, it is up for annual review. So you don't become guardian and just leave the event and never say anything or do anything after that. You continue to be under the governance of the court's authority to allow you to keep that guardianship position. So you do have to resubmit to the court, you have to pay bonds, and the court has to be assured that you are continuing in that person's best interest. Otherwise, even if a guardianship is determined, another person may be determined to be the best candidate. Now, guardianship planning for children, you can do it, especially for a child. You can set up perhaps a special needs trust for a child who does need that level of care and has, you have concerns, maybe even early on, that they will need long-term care, and you may no longer, or foreseeably, you may not be able to provide that care. That is a lot different than trust planning for children, where you just may be saying, hey, this is someone who's in an age of minority in the states that's under 18, and I want to make sure that I'm earmarking things for them, financial decisions for them, physical care decisions for them in a way that behooves them and is aligned to my wishes. If you want to protect yourself. Now, again, I can't say enough that self-care is very important when you're in a space, when you're caring for people. But it includes legal planning. You want to protect your financial future, even though you are in the space of caring for other people. Your own life, your own ability to care is not guaranteed. You want to make sure your income and your assets are not exhausted in the care of others. And you want to plan for your own incapacitation. Again, as a caregiver, you see it firsthand. You understand it might happen. And because you understand those risks, as early as you can, take those protections for yourself. It makes sense to do so. So key legal documents, a living trust, very important. That allows you to avoid a whole probate process, especially if you have capacity, and put a plan in place by putting your assets in the trust in your lifetime, and that may be for your benefit or for the care, comfort, and support of others. A pour-over will is a kind of catch-all will that allows you to say, if I didn't put it in my trust, I want it to redirect to my trust, and I just call it a one-stop shop for leaving directions for what's important and who is an important component for your structure. That may be beneficiaries, and that may be people with an authority role. A durable and medical power of attorney, durable being financial, medical being making medical decisions. I always like to stress you do not have to be both. You can have someone separate for making financial decisions and someone separate for making medical decisions. And these just trigger when you're incapacitated. So let's say you were going into surgery and they took you under, and now they have to say, can this person have a blood transfusion? In that case, you may wake up, you would be redeemed in the sense that you're no longer incapacitated, and that durable or medical power of attorney would cease. And then HIPAA, who do you want to have the information to make important decisions about you? That could be a family member or an heir, your children, a parent. It could be a friend or family member that you trust. So it doesn't have to be what the state decides. If you don't leave instructions, the state decides it's your heirs. heirs, and that goes down to your children and up to your parents. But if none of those exist, then it extends out, and it can extend out really far. It could be a very distant cousin who has authority to make decisions about you. So just be careful and mindful of that. So frequently, durable power of attorney, again, making medical decisions for someone who's incapacitated, having the right to go to their bank and pay their bank accounts or credit card bills, saying where and when the hospital will be paid and where they will go. Your medical power of attorney will allow someone to make those healthcare decisions for you that may be important. Yes, they can have that surgery. Yes, they're moving to this facility or that facility. And the HIPAA authorization is just the information. Who has the authority to hear from the physicians what's going on? If you're caring for aging parents, it's important to have all of these, available and understand who they've appointed. So those are your power of attorneys, healthcare directives, which really focuses on if there's any prolonging life efforts, if you need a blood transfusion, if you need oxygen to keep you alive, what your wishes are. And then, of course, long-term planning. They want to be cared for at home. They want to be cared for. I will step in half the day and my sister will step in half the day, whatever those wishes are. Now, at the end of the day, there will be some sort of transition, and it can be either with assistance of the court or without. If you die with a will or without a will, it has to be court assisted. And that is called probate in Texas. That process can be lengthy. And if you choose alternative, which is a trust, it can help streamline that transfer to beneficiaries. So on probate, it's a court supervised process, and it takes months or years, certainly a lot of time and resources dedicated to the process, because nothing in the court is easy or fast. While trust is a private and pretty flexible administration, allowing for beneficiaries to almost instantly access the assets that have already been given to the trust. So a few Q&A. What happens when my incapacitated child turns 18? Do I still get to make legal benefits on their behalf? Well, now the default in the courts is that they are at the age of majority. They can make decisions for themselves. And so at that time, while you are there assumed to be their guardian where they're underage, you have to go through a guardianship process when they're overage in order to continue to make all the decisions necessary for their care, comfort, and support. Second question, after being the caregiver for my elderly mother, she wants to update her will to make me her sole beneficiary. Could my siblings protest later? That really goes to her stage of capacity or incapacity. If she's capacity, meaning she can make decisions for herself legally, she understands what she's agreeing to, and comes from her, can't come from you, right? As a caregiver, if she says, I want to do this, you've done that, then certainly she can do it. But your siblings, if she does not have a trust, or if there's a public process such as probate, they can dispute her legal authority to make that decision at the time she signed. So it can't just be your opinion. It's certainly thoughtful to have a doctor or someone else come and confirm what you believe, that she has the capacity, or she or he has the capacity at any time to make a legal decision for herself. And legal decisions is different than just, hey, today was a good day. She knew who I was, right? So if we're thinking about things that are degenerative, right? And certainly mental diseases where they don't always have capacity and it's on a day-to-day basis, certainly someone could say, hey, I saw her on Tuesday after she signed the will and she didn't know where she was in the world, right? And that may be a valid challenge to what she set in place. So the earlier the better, because if not, then you have to deal with these challenges in the probate process. We are always here and happy to help. We always want to design a plan that protects you and thinks of you as a caregiver, as well as those you care for. So we certainly review and create trust for people, represent you in guardianship proceedings, and help you avoid any unattended outcomes. So if that applies to anyone watching, we certainly want to hear from you. You can always check us out at planningwithtrust.com or reach out to us on our phones at 713-574-2070. We look forward to hearing from you. We know it's a super sensitive and hard subject, but unavoidable one, especially if you're a caregiver. So I certainly understand, and we're certainly here to help if you need us.